So, once again, we have the case before us of Shante Bunch as personal representative of the estate of Martorell Williams versus Pilot Travel Center and Northeast Foods, case 23557. As you'll see on the screen, we have a clock. The yellow light will go off when you get into your rebuttal time. The 20 minutes there is shown. Each side has 20 minutes. That's your total time. We typically reserve 5 minutes rebuttal. If you want something other than that, counsel for appellant, let us know and we'll be glad to do it. Otherwise, with that, we'll go ahead, and if you're not speaking, please go ahead and mute your audio to minimize the back feed. Mr. King, you may proceed.
Thank you. My name is Tyrone King. I represent the estate of Mr. Martorell Williams. If I could, I'd like to reserve 5 minutes for rebuttal. May it please the court. We're here because the trial court granted summary judgment in favor of the appellee. This was a premises liability wrongful death lawsuit where Mr. Williams was shot and killed between two properties, the Waffle House and Pilot properties on 520 in Brevard County. The issues that create a genuine dispute of material fact, it's our opinion, were ignored or either weighed by the trial court, and those relate to an easement. I hope the court has seen from the documents that we've submitted, our briefs. There are two issues that relate to the easement. One is a lease. That lease is what the appellee refers to in terms of maintenance of the easement. The appellant, we refer to the actual easement itself. The lease is not between Pilot and Waffle House. The parcel of land that the Waffle House rests on is owned by, or was owned by, a company called C&L, and C&L leased that property directly to Waffle House. The lease that counsel and the appellees are referring to indicates that Waffle House will be responsible for maintaining the easement. The actual easement reads differently. The actual easement that's filed with the county indicates that Pilot will be responsible for maintaining the easement. The court,
Mr. King, it's undisputed Mr. Jackson shot Mr. Williams while he was on the Waffle House property, correct?
Your question is a little unclear, so I'm going to answer it this way. Mr. Jackson, the shooter, was at Waffle House. The victim was in the easement.
Okay, so but Mr. Jackson was on the Waffle House property, correct?
That is correct. That is correct.
So he shot Mr. Jackson. You're disputing whether, I'm sorry, Mr. Williams, you're disputing whether Mr. Williams was on the Pilot property or on the Waffle House property. But how would Pilot be liable if Mr. Jackson shot Mr. Williams from the Waffle House property? It would seem Waffle House, you'd have a good argument against Waffle House, but how do you have an argument against Pilot?
Well, that's the issue. These two properties had a history of having these things that the law enforcement officers called let-outs, where there were large crowds of people hanging out in both parking lots and in the easement. The people that were hanging out would come there after the nightclubs or concerts or whatever let out, high school football games, and they would go into the Pilot and purchase drinks and chips and food, and they had a Subway in there. They would purchase sandwiches, and people would go over to the Waffle House, and Waffle House had limited seating, so people would hang out until there was some seating. There was no distinction between these crowds, and both businesses benefited financially from these crowds because they wanted them there. They would allow them to purchase foods and drinks. So it was our contention that both properties engaged in creating a foreseeable zone of risk for the people that participated in these let-outs.
Mr. King, you take the position that your client, Mr. Williams, was legally there and had every right to be there. Is that correct?
That's correct, Your Honor.
Do you have a different opinion about the other, whether it was 99 or 199 people? Did they have no right to be there? Were they there illegally?
No, both entities, the pilot and the Waffle House, wanted these people there. So there's no issue with that. And the appellees did not raise in summary judgment the status of anyone as a defense or a basis for summary judgment.
Now, you say they wanted them there. Didn't they have like highway patrol? They'd hired highway patrol for security. I mean, they wanted them there. Is that in the record?
Well, they never did anything to exclude these people except when they got too loud. The off-duty deputy was assigned to pilot. Waffle House never employed anyone in an off-duty capacity. The off-duty deputy, one of them, Edward Leary, he testified, he's retired, but he testified that he would remain inside the pilot and make sure that people wouldn't steal anything unless pilot told him to go outside and deal with loud noises or remove the crowd. So pilot was aware of these crowds. Pilot dealt with the crowds how they saw fit in terms of theft inside the store. And then pilot on occasion would send the off-duty deputy out into the common area, including the easement, and remove people if they felt that it was necessary. So Edward Leary in his testimony also provides the evidence that pilot controlled the area specifically where Mr. Williams was killed. All right. That I believe answers the questions for the first point. The second issue is the court simply found that there were no crowds on the day of the incident, and that was contradicted by the record. The court wrote, this is at page 2844 of the record in its order. The court notes that these are simply allegations and arguments of counsel which do not discriminate between the two separate businesses or properties, nor does any evidence submitted support the complaint's assertion that hundreds of young people were gathering. So the court in its order eliminated the foreseeable zone of risk, despite the ample evidence that these crowds were there. According to Jonathan Kent, the detective that arrived on the scene the night of the shooting, this is in the record at 435 and at 1447. Anywhere from 100 to 300 people he described there. Also, he stated it again at 1449, 100 to 300 people. And I asked him a question. Now, is that something that's unusual for the Waffle House and the pilot to have 200 to 300 kids in the parking lot? His answer was at that time, no. So then we deposed Edward Leary, and he testified that there was a crowd at the pilot and the Waffle House. That's at record 2868 and 2054. Leary also testified, and he was there the night of the shooting. I mean, there were so many cars in the parking lot, you could not drive through. That was at 2868 and 2054. The appellant does not understand how the court could conclude that there was no evidence of hundreds of young people on the night of the incident. So the way that the order reads is that Mr. Williams was there, there was no crowd whatsoever, and there was a shooting from Mr. Jackson from the Waffle House, and he struck one person, and it's the appellant's belief that somehow pilot's on the hook. Well, no, it was a crowd of people that night, 200 to 300 people. There used to be a benefit analysis test that we used to look at, but that doesn't apply anymore. But pilot was clearly benefiting from the people that were there. They wanted them there. They could have excluded them. They could have asked them to leave. The foreseeable zone of risk argument that we raised, the court rejected that as well. And that was primarily because the court excluded the expert witness that we filed an affidavit on behalf of. Court didn't exclude him. The court simply said, I reject his testimony. And there was no basis indicated in the order for the rejection of his testimony. The court indicated that he he made some facts or stated some facts that weren't in the record. The only fact that the court addressed at the hearing was that Mr. Zuvas stated that Mr. Williams, there was no independent evidence that he had a gun. That was a direct quote from Detective Kent, and he gave attribution for that direct quote. So other than that, there was no basis for the court to reject the affidavit. Mr. Zuvas testified by affidavit that he had reviewed all of the police records. He reviewed the depositions, the transcripts, the interrogatories. He reviewed the prior crime calls for service for both properties, and he reviewed the police reports for both properties from 2002 to 2007. He applied the ACES methodology for foreseeability. He went through that, and he offered an opinion that violence at this property was foreseeable. And he based that on not only those reviews, but 2 instances. 8 months before the shooting of Mr. Williams, there was a large crowd in the property, and the police officers indicated that that large crowd got out of hand. 7 months before the shooting of Mr. Williams, there was another large crowd on these properties, and there were shots fired. So the appellee was well aware of the potential for violence at the property, these large crowds existing, or they should have known of this. And Mr. Zuvas's affidavit should not have been rejected. That was the basis.
Mr. King, how can Pilot stop the incident that happened on the Waffle House property? I mean, you just agreed that the shooting started from the Waffle House property. So how is Pilot liable for that? You still kind of danced around that question a little bit.
Well, actually, the case law that we've cited indicates that prevention is not the test. And I'll get to it in a moment, but prevention is not the test. That's causation. So that would be left for a jury to decide whether or not reasonable security measures could have prevented this. What we proposed and what Mr. Zuvas proposed in his affidavit was that Pilot could have simply sent the off-duty deputy out there to clear the area, eliminate the victim as opposed to eliminating the shooter. Send the officer out to stand in the easement area that they controlled. We know that after the shooting, the shooter ran and tossed his gun. It wasn't as if he shot Mr. Williams and stood there waiting for law enforcement. He didn't want to be captured, and he didn't want to be seen by law enforcement. So if the off-duty deputy that was inside the Pilot preventing theft of Cheetos or theft of soda had gone out into the parking lot where 7 months earlier there had been shots fired and removed the crowd or showed a visible presence, the shooting more likely than not would not have occurred. That would have been what we would have presented to a jury, but we weren't given that opportunity because the court took away.
Yeah, Mr. King, I need to follow back up on Judge Boatwright's question again. What duty and what authority, well, what duty, we'll leave it at that, does Pilot have to control who's on the Waffle House property?
Well, Mr. Williams was not on the Waffle House property. Mr. Williams was in the
I know that.
So
Mr. Williams didn't shoot himself.
Right.
Mr. Jackson shot Mr. Williams from the Waffle House property. Now just tell me straight out, what duty do they have to control who's on the Waffle House property?
Well, they have a duty to control the easement, which is the only access point to the Waffle House. So Mr. Williams,
So you're saying it'd be okay under the easement, it'd be all right if whoever's at Pilot in charge that day looks over and sees 15 people at Waffle House, says, we're shutting you guys down, that's it?
Oh, no, they had no authority to shut down Waffle House. The Pilot had no authority to do that.
So we're going to prevent access. We're not going to let anybody else on your property. We see 15 people there. We see 20 people there.
No, they could not do that under the easement. They couldn't shut down the easement. But that's what Zipkin addresses.
Then how do they have a duty if they can't restrict who goes to Waffle House? What's their duty to deal with people at Waffle House?
Access the ability to stop access doesn't eliminate the duty. And that's what Zipkin talks about, Zipkin versus Rubin at 418 Southern 2nd. In Zipkin, the owner of the easement argued, I can't shut it down. I can't shut down the easement, so my duty's eliminated. And the court stated that at the outset, we reject Wilkinson's contention that the legal effect of the easement is to relieve him of all liability to third parties. It states that, however, Wilkinson's premise is incorrect. The basic tenet of the law is that the possessor of land subject to an easement created by conveyance is privileged to make such uses of the servient tenement as are not inconsistent with the provisions of the easement. So Pilot could have done anything with the easement and people in the easement other than restrict access. They could have sent a security guard up there.
But your whole premise, I thought, was they were allowing too many people to gather.
Oh,
On their property or on the other property. It's all about the crowd, you say.
It is, because if you eliminate the victims, you eliminate the shooting. So don't allow these crowds. Don't allow these people to gather and hang out in the easement and at the Pilot. If Pilot eliminated the people that were hanging out in the easement and on their own property, the Pilot property, there's no one for them there's no one for Mr. Jackson to shoot. Waffle House would have to deal with any issue. This is no different. This is no different than if I and my law partner live next door and we're having a block party with people mulling between our two houses. I'm participating in creating this foreseeable zone of risk. If someone shoots from my partner's house and injures someone in my front yard, I'm responsible for that as well, even though the shooter was next door. I participated in creating this foreseeable zone of risk by allowing this crowd in my front yard. And that's what Pilot and Waffle House did. And I will reserve the rest of my 3 minutes and 45 seconds.
All righty, very well. Counsel for Pilot.
May it please the court, and Your Honor, I apologize for the technical issues that I had before.
Not to worry.
Let me start by addressing the issue of weight, whether the trial court weighed the evidence or discredited the witnesses. That's not what the court did. And if you look at the order, the issue in that order is all about duty, whether Pilot had a duty to protect the decedent. And in doing that, the court really didn't make any factual determinations with respect to the crowd. What the judge did say, the trial court did say, was that it found that a crowd in and of itself is not a dangerous condition. And plaintiff's argument misses the point. That's the central issue. That's the crux of the order of how the court ordered and why the court entered summary judgment. And I know that plaintiff cited a case, I believe it was Sherwood versus Quietwater Entertainment, to say that crowds are always they're always dangerous. But if you look at the Sherwood case that he cited, it's a crowd. Yes, there was a crowd, but there was also alcoholic beverages involved in that case. And because there were alcoholic beverages, it's common sense that these fights would occur. And we cited a couple. I could not find any case in Florida that said one way or another that a crowd isn't in and of itself a dangerous condition. But I did find two cases outside of the jurisdiction, and I cited in my brief.
Well, counsel, if I could interrupt and ask a couple of questions.
Of course.
What does the records say as to the security officers at Pilot? What I saw was that there was 3 officers on site at the time of this incident. Are they there just to keep people from shoplifting Fritos, or are they actually going into the parking lot and making sure there's a safe environment for the patrons?
No, Your Honor. There were 3 officers. There were 3 Florida Highway Patrol officers. They were armed with uniforms, and there were 3 patrol cars were there. And Mr. Leary, Florida Trooper Mr. Leary, who opposing counsel cited to, he stated in his deposition that the reason why, and this was pursuant to an agreement with FHP, Pilot had an agreement with FHP, that the reason, and this is his quote, that the reason they were there was essentially to keep them crowds out of the Pilot. That was why they were there for, Your Honor. And that's what they were trying to do.
Okay, so it's a crowd control measure that Pilot
Correct,
had in place. All right.
correct.
So they understood they had a duty to ensure that their property was safe and that the crowds caused a safety issue.
They're on their property, Your Honor. Yes, absolutely.
And
The-
to get to the Waffle House, you had to go through their property.
Correct. There's a shared driveway.
Okay, so
And the
so the
issue-
neighbors, so the Waffle House and Pilot are neighbors essentially.
Correct.
They both have this, they're both sharing this problem to some extent of massive crowds that come in. I say massive, it sounds like 200-300 people, which sounds to me like a pretty good crowd for a Pilot and a nearby Waffle House. So they have a responsibility to ensure the safety of everyone on their property, but also since they control the easement, they need to have at least some duty as to that, don't they?
Well, Your Honor, it's our position that they don't control the easement, because if you read the lease and you read the declaration of easement, which you have to read together, you cannot read them separately. If you look at the entity that controls, that maintains, that has possession of the easement is Waffle House. Now, could Pilot use the easement to get, back and forth? Yes, they could, but they couldn't stop anybody from using it. They couldn't put blockades from people from using the easement, from crowds coming onto the property. They couldn't do anything like that. And one of the issues, one of the hallmarks of negligence law and premises liability law is you have to have the ability to prevent access to the property, to be able to prevent the very issue that's causing the accident. And in this case, they couldn't. A Pilot could not have put a security guard in front of that driveway and said, no more. No more people can come onto this property. They couldn't do that. They couldn't put blockades to do that.
The crowd problem, I mean, wasn't there some evidence that there was actually gunfire at some point in the past from one of these crowds?
Your Honor, there was a line in Mr. Zuvis's affidavit that he said that. Now, if you look at Mr. Zuvis' affidavit, he doesn't provide that documentation to back that allegation. And that's the problem. And that was the issue. And that was the reason why the court rejected and struck his affidavit. Because while he said all these things, that that Pilot was negligent, that the shooter was on Pilot property, that the victim was on Pilot property, he doesn't back it up. If you look at his affidavit, there's nothing to back up any of the allegations, any of his points, or any of his opinions. And that was why the court rejected it.
Why is the property line the tort line as well? Why is the property line sacred and the liability on one side but no liability? Because if this happened on Pilot's property, that you have a different story, right?
Correct. Absolutely, Your Honor.
So you would agree that if this happened on Pilot's property, there perhaps would be a viable negligent security claim for allowing these crowds to gather. So why does the foreseeability of these massive crowds, potentially in the past having maybe some gunfire, having some effect on the patrons and others who go to Waffle House? Why does this property line dictate the result?
Well, one is because the case law is pretty clear in Florida, and I hate saying that to you because you're farmer, you know all about this, but you have to have the right to control access to the property. And in this particular case, Waffle House could not restrict access to the easement nor to the Waffle House property.
Oh, well, yeah, but they had the ability to control the crowds. And if you had, I would assume that if you have controlled number of, you control the number of people who get access to the property, that you're going to have a less likelihood of these things happening, correct?
Correct. If they can control their property. That is absolutely the truth. That is, there's no denying that. That's undisputed. But they can't control.
But you're not saying that some of these folks that congregate in the Pilot parking lot aren't going over to the Waffle House. I mean, it sounds to me from what I read of the record, this is a big event, a big group of people, big gathering, and lots of folks go back and forth between the Pilot and the Waffle House.
Yes, Your Honor. But Waffle House can't restrict that. They can't restrict the use of the easement one way or the other.
Yeah. Well, I'll ask you one last question. I'm sorry for
Sure. And I apologize if I'm not answering your question.
That's why we're here. I thought Mr. King made a very powerful analogy in saying that if he and his neighbor have a block party, it really doesn't matter where the shots are fired from and if they're sort of both jointly contributing towards the problem, then they both perhaps have a responsibility. And here, it doesn't sound like a Waffle House was the one necessarily creating the problem overall. It was the massive crowds at the Pilot that were getting lots of folks in, including the ne'er-do-wells who decided to have a gunfight. So why shouldn't Pilot at least have some legal responsibility here?
Well, because Your Honor, if you really get into the meat and potatoes of this case, the issue really wasn't the crowd. The crowd really is a red herring and irrelevant, because the record evidence shows that the reason this shooting occurred was because the shooter, the original shooter, basically made sexual advances on the decedent's girlfriend. Okay, the decedent then sought out where the shooter was located, and that's how it occurred. So basically, what happened here was 5 minutes after the shooter arrived, after arriving, the decedent arriving on the property, on the Waffle House property, in the medium or the Waffle House property, he shot at the shooter. The shooter returned the shot. Just like that, Your Honor. So this would have happened in the IHOP, in the street, in the Waffle House, in the Pilot. It didn't matter what occurred. So I think that's really important here, because in the end, the crowd in and of itself did not cause the accident. This is not something where the crowd chanted to shoot. It was not where the crowd decided to trample or anything like that. This was someone who personally targeted this individual and shot. And in those cases, there's nothing we can do.
Right. So there's no excuse me. There's no evidence that these crowds that have been gathering there had any significant gang component.
No, Your Honor. And if there was, I guarantee you that opposing counsel would have cited that.
Okay, thank you.
You know, unless anybody has any questions, I'll be more than happy to acquiesce, because I think our position is rather clear. The issue of duty. I do want to touch upon on the issue of causation, though, because one of the arguments that appellant makes is that the court decided causation, and that's not true. If you look at the order completely, it's all about duty, and duty does and although the order does talk about foreseeability, that foreseeability is what occurs is basically just referring to the duty element, foreseeability. And even if that wasn't the case, even if there was the decision of causation, the court is more than welcome to do that. They can, if all the facts point to one way. Again, I could sit here and pick apart each of their arguments, but if there's anything that you want to know specifically from us, I'll be more than happy to acquiesce the rest of my time to Mr. Keene. But I think our brief states what the brief states what we need to state. I believe I've answered the questions that are pertinent, unless there's other questions. And I believe the record evidence speaks for itself.
You brought up foreseeability, which does raise a question, because obviously foreseeability has two functions in the tort system. One is to define the scope of the duty. Then, assuming there is a duty, what actually happened was factually foreseeable and the facts presented. That's typically a jury question, but not always. So, I mean, here it seems to me the scope of the duty is a function of the evidence presented as to the risk created. And if the gathering crowds that actually required a substantial Florida Highway Patrol presence, if that's the fact pattern, crowds that required Highway Patrol to have order, at least in the sense of not have overcrowding. It seems to me that there's a recognition, there's a duty there. It's foreseeable enough that harm could arise from this situation that we had police presence. So doesn't that in your mind at least create some basic duty on behalf of Pilot, not just for its own property, for anyone that, I mean, because if a gun was shot from Pilot's property and hit someone sitting at the Waffle House, I mean, just because the bullet hit the person at the Waffle House doesn't mean Pilot's off the hook.
Well, if the gunshot, I agree, Your Honor, with that. But again, this was a personal targeted attack. And,
right, but that goes to the second foreseeability, which is on the facts of this case. That's a pretty strong argument. Hey, nothing that happened that evening with the crowds and all, the police presence, all that had nothing. This was just a random gang-related shooting over someone looking at someone else's girlfriend.
Well, if it was truly random, then there's a stronger argument that there might be a duty if it was random, because ultimately although there's no common law duty to protect from criminal acts, unless the exceptions occur, unless the 3 exceptions, which we don't have here. There's no control of premises, easement or Waffle House. There's no control over the instrumentality of the attack, which was the gun, and there's no control over the tortfeasor. So we don't have that. So there's no exception to that general rule. But again, but having said that, there is a duty on the part of a landowner to protect from general criminal activity. But when it's a specifically targeted attack, there is no duty to protect, because it would be impossible. And in my and in the brief, we cited the Reichenbach case versus Days Inn of America Inc., which is 401 Southern 2nd 1366, and it's from your court. And it's and I'm citing Judge Howard's concurring especially, and he says there's no reasonable standard of care should require one to ever be on guard, ever present, ready and able to prevent an unforeseeable personal criminal attack upon another. And that's what we have here. It's a personal criminal attack. And that's why the duty element.
I'm sorry to interrupt you. I apologize. Was your summary judgment motion predicated upon that issue as well? I apologize.
It touched upon that, Your Honor. I will be honest with you, it wasn't as fully fleshed out as I would like it to have been, because I did not write it. But it did touch upon the fact that it was this personal attack. And one last, and I just want one point out is that if you look at the Daly versus Denny's case, which is the one case that the trial court really relied upon, I think it's on all fours. It's very similar incidents. The assailant traveled from the motel parking lot onto the Denny's parking lot and mugged, assaulted a woman on that parking lot. And in that case, the court found that there was no duty on the part of the motel owner to protect the plaintiff who was on another adjacent property. So I would point that that's the case that really is the linchpin of the argument. It's the linchpin of our argument, and it's the linchpin of the summary judgment argument.
All right. Unless my colleagues have anything else, we'll turn it back over to Mr. King.
All right, Your Honor, thank you very much.
Yes, sir. You have 3:44 left to go. We both need to unmute.
Okay, let me first address this issue of a targeted attack. They attempted to argue that at the trial level, and there was no evidence to support it. And in this record, there is no evidence to support a targeted attack. There's no witness that talks about a girlfriend. This is all what they believe that they would have been able to prove at trial, but there's nothing in the record to support that. And it's so deficient that they abandoned that argument on the summary judgment level. They filed a motion for summary judgment, attempting to make these arguments, attempting to allude to the fact that Mr. Williams had a gun, and that's what the court was speaking about. If you look at the order, the trial judge said that they abandoned that argument because they could not find admissible evidence for the purpose of summary judgment. With regard to the officers, the court is correct. They were fully aware of the dangers associated with these crowds and had off-duty inside. They were more concerned, again, about their products and the theft that might occur inside than they were about the instance of prior shooting outside. They could have easily sent the officers outside and asked them to disperse the crowd, like Mr. Leary testified that he had done in the past. But they didn't do that in this case.
Mr. King, back to the appellee's argument as to the crowd being a red herring. Was the shooter part of this crowd?
Yes, the shooter drove there with two other women, I believe it was, and sat in the car. And the car that he sat in was parked in the easement. When the crime scene investigators photographed that area, the car was still sitting there. The car that he got out of and went over to the Waffle House. He had no intent. This person had no intent of making any purchases or anything. He went over there to cause trouble. Mr. Williams had called one of his friends, and that's in the record, and they were going in and making purchases at the Pilot. So Mr. Jackson was the one that showed up and wanted to create problems at the property. This Daly versus Denny's case, the court relied on that, but it's a totally different scenario. In that case, there's no connection between the hotel, the motel, and the Denny's. There's no easement. There's no history of them having crowds hanging out in the parking lot together. It's a totally different scenario. The victim and the shooter in the Daly's case were on Denny's property. They weren't on the motel property at all. There's the shooter and the victim. The shooter and the victim were admittedly on adjacent property. I don't know how the motel would have had any liability whatsoever. It would just be, using my analogy, it would be me being responsible for my neighbor's shooting if my neighbor was having a block party and I was in my house watching football. So the Daly's case just doesn't apply. We would ask that the court reverse summary judgment and allow this case to proceed to a jury.
All right, thank you very much. Well briefed and well argued. We'll be in recess.
Thank you, Your Honors. Have a great day.